Hi guys! Welcome to Jumadeconsulting channel. Today we will talk about how medical scientists and other professionals from any part of the world can obtain U.S. green card through employment-based visa application. Let's dive into it. Employment-based immigration second preference with National Interest Waiver (EB-2 NIW) is the visa medical scientist and other professions can apply for green card if you want to migrate to United States. Applying for an EB-2 National Interest Waiver (NIW) involves a multi-step process. The EB-2 NIW is a category of employment-based immigration that allows individuals with exceptional abilities or advanced degrees to obtain a green card without the need for a job offer or labor certification, provided they can demonstrate that their work is in the national interest of the United States. This visa does not have an age limitation. Here is an overview of the process. Determine your eligibility. Confirm that you meet the eligibility criteria for the EB-2 NIW category. Typically, applicants must have an advanced degree or exceptional ability in their field. If you have a master's degree or PhD, you are already qualified. You don't have to have exceptional abilities. You will be qualified to apply for this category if you have a bachelor's and demonstrate exceptional ability in your field, proven through substantial evidence and accomplishments. Eligibility criteria for advanced degree professionals. Applicant must meet at least 3 of the 6 eligibility criteria. Eligibility criteria. 1. Official academic record showing that you have a degree, diploma, certificate, or similar award from a college, university, school, or other learning institution relating to your exceptional ability. If your degrees are not from the USA, ensure you do a conversion assessment to the USA equivalent, like World Educational Services, WES. 2. Letters from current or former employers documenting at least 10 years of full-time experience in your occupation. Make sure you can get a reliable former or current employer to attest to your 10 years of experience in the profession on the company's letterheaded paper. 3. A license to practice your profession or certification for your profession or occupation. Provide certification, license about your profession. 4. Evidence that you have commanded a salary or other remuneration for services that demonstrates your exceptional ability. Get your payslips as evidence that your pay rate is higher than average staff because of your exceptional ability, and explain using the National Pay Handbook for your profession. 5. Membership in a professional associations. Get all the documentation and your participation in professional associations. 6. Recognition for your achievements and significant contributions to your industry or field by your peers, government entities, and professional or business organizations. These documents may include awards, letters of honor, and various acknowledgments of governmental appointments or contributions. 7. Other comparable evidence of eligibility is also acceptable. These include research publications, grants, mind-blowing inventions, and anything worth of importance that should be mentioned. Prepare required documentation. Gather evidence to support your eligibility and establish that your work is in the national interest. This may include letters of recommendation, educational and professional background documentation, awards, publications, and any other relevant achievements. Draft a petition letter or cover letter. Write a comprehensive petition letter explaining how your work benefits the United States and why it is in the national interest to waive the job offer requirement. Clearly demonstrate your qualifications and the impact of your contributions. Under the following headings. Table of contents for cover letter. Form I-140 and letter of introduction. Chapter 1 Advanced degree, exceptional ability, employment history. Chapter 2 Proposed endeavors, substantial merit and national importance. Chapter 3 Well-positioned to advance the proposed endeavor. Chapter 4 Beneficial to the United States to waive the job offer and labor certification. Petitioner's non-immigrant status. Petitioner's dependent status. Conclusion. Documents, list of evidence. Chapter 1 Advanced degree, exceptional ability, employment history, certification. Itemize your 3 chosen eligibility criteria and discuss them in detail with the title above. Note: you can choose what suits your situation, which may not include certification. You chose from above. Prepare a persuasive cover letter detailing the applicant's education, presentation, and description of your university. The GPA and thesis must be presented impressively. If you have more than one degree, describe your projects and how they can benefit the USA. If you have exceptional abilities, detail them. This cover letter may be as long as 40 pages or more. Address in detail the endeavors that qualify for a national interest waiver under provide evidence showcasing how work benefits the United States on a broader scale, addressing the following USCIS requirements. A. The proposed endeavor has both substantial merit and national importance. B. The applicant is well positioned to advance the proposed endeavor. C. On balance, it would benefit the United States to waive the requirements of a job offer and, thus, the labor certification. Chapter 2, Proposed Endeavors: Substantial Merit and National Importance. When you get to the U.S., write what you intend to do that will be in the United States' national interest and have substantial benefits. Make sure what you intend to do will impact the whole United States, not just a state or a region of the United States. Get detailed recommendation letters, up to 5, from people in your field who can support your application, agreeing your contribution will be of national importance and substantial merit. Some may decide they will be starting a business, for instance, relating to their profession. Such people must write a detailed business plan explaining the feasibility of the endeavor, and the plan must cover the whole nation. In this aspect, the applicant has to be as practical as possible. If you intend to work in your profession, for example, give supporting evidence of the company you have exchanged emails with, and they are willing to employ you if you get your green card. If the applicant is vague in this section, it will harm your application. Chapter 3, Applicant well positioned to advance the proposed endeavor. The applicant must prove the ability to perform the endeavor stated above. For instance, to be employed, state all you have that makes you employable in the market despite competition or the capital to back up the business plan, contributors' accounts, or grants available. Failing to prove you are well positioned to perform your proposed endeavor could cause refusal. Therefore, be diligent in presenting persuasive data and figures. Chapter 4, On balance, it would benefit the United States to waive the job offer requirements and, thus, the labor certification. How will the endeavor's applicability benefit the United States if they waive the job offer and labor certification? Applicants must understand that labor certification is a process through which employers in the United States demonstrate that no qualified and willing U.S. workers are available to fill a particular job position. Therefore, they need to hire a foreign worker for that position. But the petitioner is asking USCIS to waive this process. Explain the contribution you will make to the U.S. that warrants foregoing this process for you. It's important to note that obtaining a labor certification waiver through the national interest route is a complex process, and applicants must present a strong case that clearly demonstrates the national significance of their work and benefits. It is important to get recommendation letters that state support why the job offer should be waived for you. The best way to use the recommendation letters is to use the commendation statement to back up your write-up. Guidelines for USCIS labor certification waiver. Here are some reasons why USCIS labor certification might be waived in the U.S. National interest. The primary justification for waiving labor certification is that the foreign worker's employment is in the national interest of the United States. This could be due to their exceptional abilities or advanced degrees, and the nature of their work is deemed to benefit the nation as a whole. Contributions to the field. Suppose the foreign worker can demonstrate significant contributions to their field, innovations, or advancements that are valuable to the U.S. In that case, it may be considered in the national interest to waive the labor certification requirement. Economic impact. If the foreign worker's work is expected to positively impact the U.S. economy, such as job creation, stimulating economic growth, or addressing a critical shortage of qualified workers in a particular field, labor certification may be waived. Research and academic achievements. In cases where the individual is involved in research, academia, or other areas of national importance, their achievements and contributions may be considered significant enough to warrant a waiver of labor certification. Public health or safety. Work that directly contributes to public health, safety, or welfare may be deemed in the national interest. justifying the waiver of labor certification. The applicant must explain that they will not harm U.S. citizens' jobs by waiving the job offer, that the benefit outweighs the disadvantage of not waiving it, and that the action is balanced. Petitioner's non-immigrant status. The term, petitioner's non-immigrant status, refers to the current immigration status of the individual filing a petition. How did you come to the U.S.? From the entry, you must download Form I-94 stating entry details and expiration date. The visa class will be on the form. But if the applicant is outside the U.S. state where you are, understanding the petitioner's non-immigrant status is crucial in the visa application process, as it ensures that the individual filing the petition has the proper legal standing. Petitioner's dependent status. State the dependents migrating with the applicant. Conclusion. Write a summary of the application and give a resounding, convincing conclusion. Signature of applicant. List of documents. All the documents must have numbers and items in sequential order. Submit supporting documents. Include all necessary supporting documents with your Form I-140 petition and labor certification forms. Ensure all forms are signed with pen. This may include educational certificates, letters of recommendation, proof of employment history, and other relevant materials. The important forms to be completed for the EB-2 NIW. All forms must be downloaded from the USCIS official website. The forms are continually revised. If the applicant uses an old version, the application will be refused and sent back for the applicant to correct the error and check the dates and versions. 1. Form I-40. File Form I-140, Immigrant Petition for Alien Worker, with U.S. Citizenship and Immigration Services, USCIS. Include the required filing fee and supporting documentation, such as the petition letter and evidence of your qualifications. 2. I-9089 Labor Certification. These forms have a detailed employment history and are in 2 parts. It must be filled appropriately to avoid refusal to process. 3. I-907 for premium processing, optional. You can apply for premium processing if you want your form to be processed within 45 days instead of the long wait. 4. G1145E Notification. This form is a page for electronic notification instead of manual postage, but it is optional. USA phone number only. Pay filing fees. Pay the required filing fees associated with Form I-140. Check the USCIS website for the most up-to-date fee information. You have the option of using premium processing. I is very expensive but good for peace of mind and earlier priority on Visa Bulletin instead of waiting longer. Ensure your package is well assembled, no staple pin. If you are posting to Lockbox, you can use color stubs. This how I package my application to the Lockbox. Wait for USCIS processing. USCIS will process your petition and may request additional evidence or documentation. Be patient during this stage, as processing times can vary. Receiving action of notice. Understanding Form I-797, Notice of Action from USCIS. Notice of Action from USCIS. The Notice of Action, Form I-797, is a document issued by the U.S. Citizenship and Immigration Services, USCIS, to communicate information about an immigration petition or application. It serves as an official notice to the petitioner or applicant and includes crucial details regarding the status or processing of the case. The Form I-797 can take different forms, and each type has a specific purpose. Here are some common types of Form I-797. Receipt Notice, I-797C. It was issued to acknowledge that USCIS has received a petition or application. It typically includes a receipt number, which can be used to track the case status online. Approval Notice, I-797A. It is issued when USCIS approves an immigration petition or application. It provides details about the approved benefit, validity period, and any conditions associated with the approval. Transfer Notice, I-797C. Issued when a case is transferred from one USCIS service center or office to another. It provides information about the transfer and may include the new receipt number. Request for additional evidence, I-797 East. It is issued if USCIS needs more documentation or information to complete the processing of a petition or application. It specifies the evidence required and provides instructions on how to submit it. Notice of Intent to Deny, I-797C. They are issued when USCIS is considering denying a petition or application and allows the applicant to respond before a final decision is made. It's important to carefully review the information provided in the Notice of Action, as it contains critical details about the status and progress of an immigration case. Applicants should follow any instructions provided and, if necessary, seek legal advice to address issues or respond to requests for additional evidence. After approval of I-140, adjustment of status or consular processing. Once your Form I-140 is approved, you can proceed with the next steps based on your immigration status. This may involve adjusting your status within the U.S. or consular processing if you are outside the country. Wait for visa availability. If you are subject to numerical limitations, you may need to wait for visa availability, especially if applying for adjustment of status. Check the visa bulletin regularly for updates on visa availability. Complete Form I-485, if adjusting status. If you are in the U.S., file Form I-485, Application to Register Permanent Residence or Adjust Status, with USCIS. Include the required filing fee and supporting documentation. Attend biometrics appointment. If applying for adjustment of status, attend a biometrics appointment as scheduled by USCIS. Biometric Appointment Notice, I-797C. Issued to inform applicants of the date, time, and location for biometric, fingerprinting, appointments. This is common in cases where background checks are required. Interview Appointment Notice, I-797C or I-797A. Issued for adjustment of status or other applications that require an in-person interview. It provides details about the interview's date, time, and location. Denial Notice, I-797B. Issued when USCIS denies a petition or application. It includes the reasons for denial and information about the appeal process, if applicable. Wait for decision. USCIS will process your application and notify you of their decision. If approved, you will receive your green card. Disclaimer. It's important to note that immigration processes can be complex, and it's advisable to consult USCIS websites for updates, to ensure that you meet all the requirements and submit a robust application. The information provided here is a general overview and may not cover all individual circumstances or updates to immigration laws and procedures. I am not a lawyer or migrant agent. I am a medical scientist, with personal experience. If you need any help with the application or writing the business plan, I will gladly guide you at a reduced fee. Contact me at medicalscientist23@gmail.com.